that. Mr. Plant, all right, first, and sir, have you had an adequate opportunity to review both the pre-sentence report and the sentencing guidelines with your attorney?
Yes, I have.
Okay. I'm going to go over the changes that we made the last time, and then I'll give each one of you an opportunity to make any additional changes. Let's start with the sentencing information report. PRV 2 was changed from 30 to 20. Everybody agrees with that change still?
I do, Your Honor.
Yes, Your Honor.
Then the next change I have is PRV 5 was changed from 20 to 15. Everybody agrees with that change?
People do, Your Honor.
Yes, Your Honor.
And then that changes the total PRV level to 55 instead of 70. Is everybody agreeable with that?
We agree, Your Honor.
Yes, Your Honor.
And that leaves it at a PRV level of E. Everybody's agreeable with that?
Yes, Your Honor.
Then with regard to the offense variables, OV1 is changed from 25 to 0. Is everybody agreeable with that change?
People agree.
Yes, Your Honor.
And OV3 is changed from 50 to 25. Everybody's agreeable with that change?
Yes, Your Honor.
People agree.
That changes it to a total OV level of 30. Is everybody agreeable with that change?
Yes, Your Honor.
Yes, Your Honor.
And it changes the OV level to 3 instead of 4. Everybody's agreeable with that change?
Yes, Your Honor.
Yes, Your Honor.
And that changes the guideline minimum range from 58 to 114 to 36 to 71. Is everybody agreeable with that change?
That is the correct range, Your Honor.
Yes, Your Honor.
Any other additions, corrections, deletions, factual changes to the pre-sentence report other than ones I've already talked about, first of all, from the people?
From the sentencing information report, Judge?
And also the pre-sentence investigation report.
We have no other changes other than, I'm sure the court will discuss in a moment, there was, in the new report, there is a change to the credit. But other than that issue, we agree with the report. And we agree with the new credit, but we agree with the report.
And the new report reflects that number that you're indicating, 190 days. Is that correct?
That's correct, Your Honor.
All right. And you've had an opportunity to go over that with the agent to prepare this report and have the explanation of those days. Is that correct?
I have had an opportunity to go over that information, Judge. On page 2 of the report, it does give the specific dates in which the agent used to determine that total of 190. Before I even had spoken to her, I had gone over what I believe the credit should be based on my notes, and I believe the 190 days is correct.
Okay. Counsel, you have an opportunity to go over with that with her and your client?
Yes, Your Honor. I've had occasion to discuss this, the changes in the jail credits with the writer of the report, the agent who's present in the courtroom right now. I talked to my client about it. I cannot, from a factual basis or any other basis, quarrel with the change in the finding of jail credit, Your Honor. She's present here if the court wants to voir dire her about it. I talked to my client. The difference is substantial, but I understand how she came to the calculation.
Okay. Anybody need me to voir dire her with regard to this matter?
We don't, Your Honor. We're in agreement with 190 days.
I don't need you to do that, Your Honor.
All right. Anything else from the people as far as any additional additions, corrections, deletions, factual changes to either the pre-sentence report or the sentencing guidelines?
We have none, Judge. Thank you.
All right. Counsel, have you had an adequate opportunity to review both the pre-sentence report and the sentencing guidelines with your client?
Yes, Your Honor.
Any additions, corrections, deletions, factual changes to either of those documents?
No, Your Honor.
Mr. Shortie, have you had an adequate opportunity to review both the pre-sentence report and the sentencing guidelines with your attorney?
Yes, I have.
And let's have Mr. Shortie sworn in.
Raise your right hand. Do you swear affirm the testimony you're about to give before the court is the truth?
Yes.
Could you state your name for the record, sir?
Clifton Shortie.
And Mr. Shortie, you had an adequate opportunity to review both the pre-sentence report and the sentencing guidelines with your attorney. Is that correct, sir?
Yes.
Is there any additions, corrections, deletions, factual changes you wish to be made to that pre-sentence report?
Yeah, it's 2 months short of what it should be.
It's too much what?
2 months short. It should be 60 more days added on to that.
Okay, you're talking about with regard to the jail credit?
Credit days, yes.
Okay. Any other additions, corrections, deletions, factual changes other than that request?
Everything else is right.
Okay. And the court can rely upon that report other than you're disputing the jail credit, but everything else the court can rely on as being factually correct. Is that correct, sir?
Yes.
Okay. Could we have the agent please stand up? Agent, could you state your name?
My name is Yolanda Gadsden.
Okay, and you've prepared this report, is that correct?
I did, Your Honor.
And you've gone over the jail credit that Mr. Shortie should be assessed with regard to this matter? Is that awarded
Yes,
with
Your
regard to this matter? And the amount of time that you found is what number, ma'am?
It is 190 days.
Anybody else have any additional questions for the agent from the people?
Just briefly, the information that you obtained to determine this 190 days, where did you obtain the information from?
I obtained that information from the Wayne County Jail as well as the Wayne County Jail Tether Unit.
And did you understand that they obviously keep track of when in this case, the defendant would have come into the jail system and exited the jail system either by bond or other means?
That is correct.
Okay. And you're confident with the 190 days?
I am confident, yes.
Nothing else, John?
Counsel, any
Nothing
questions?
from the defense, Your Honor.
All right, Mr. Shortie, do you have any questions?
No.
All right, Jane, you can have a
Thank you.
seat. Thank you very much. All right, counsel, what would you like to say on behalf of the people before the court imposes sentence?
Judge, we would ask, there is a sentence agreement in this matter. We would ask the court to follow that sentence agreement. And when appropriate, we'd be asking the court to dismiss counts 2 and 3.
Counsel?
Your Honor, I'll incorporate what I've said on the last occasion.
Oh, I'm sorry. Is there anybody here that wishes to speak on behalf of the victim?
Judge, the last hearing there was not. I don't.
Is there anybody that's here that wishes to speak on behalf of the victim in this matter? Anybody wishes to speak on behalf of the victim? All right, the record to reflect nobody's indicated they wish to speak on behalf of the victim. Go ahead, counsel.
Your Honor, I would just ask the court to incorporate what I've indicated at the last hearing and before we adjourn this matter to check into the jail credits. I do note that this was a Cobb's sentence agreement in which is at the lower end of the guidelines. I do note that Mr. Shortie is a habitual four. I do note that he's had contact with the system. I know that the circumstances that bring us into this court are tragic. The standard in which the plea was taken is, as this court knows, is not what we say in law. You don't have to have an intent to do something. In this particular case, there's a negligence factor in it, the fact that a gun was left under the control of the defendant and someone was killed by the gun. We understand why we're here. I thank the court for not vacating the sentence agreement. I think that's remarkable of this court, and I ask you to sentence him accordingly.
Mr. Shortie, this is your opportunity to speak to the court before I impose sentence. Anything you'd like to say, sir?
The gun wasn't mine. That's about it. I feel sorry for what happened to the victim. He didn't deserve it. That's about it.
All right. All right, well, Mr. Shortie, this is a very, very unfortunate case. And there is no winners in this case. There's only losers in this case. And your negligent actions, reckless actions, have caused both families a lot of pain and grief and sorrow that they'll never get over. But I do want to point out a few of the things that you did here which were just absolutely reckless. First of all, to leave a loaded shotgun in the basement is just completely reckless by you. And then not only to leave that loaded shotgun in the basement, but then to leave a 17-year-old to oversee a 10-year-old and a 14-year-old with a loaded shotgun in the basement. It's just unforgivable, sir. And due to what you did, this young man lost his life, and it's my understanding he had a bright future, and it's really, really a sad case and an unfortunate case. But I think that the sentence agreement in this matter, the court is going to adopt the sentence agreement in this matter. I think that it's a fair sentence with regard to all the facts with regard to this case. And therefore, with regard to the felony firearm, I am going to sentence you, which is a mandatory sentence of 2 years to the Michigan Department of Corrections. Then the next, the involuntary manslaughter will be served consecutive to that, and that will be a minimum of 36 months to a maximum of 15 years. You will receive 190 days jail credit served. And one other change I'm going to make on the document, counsel, is on page 2. At the top, it says 190 days, but then in the body of it, it says with credit for 380. I'm going to change that to 190. Are you both agreeable with that?
Yes, Your Honor.
All right, I'm changing that to 190. So 190 days jail credit served. You also are to pay $136 state costs, $130 crime victims assessment, $600 court costs. Sir, you may file an application for leave to appeal your conviction and sentence. If you choose to do so, you must do so within 42 days. If you cannot afford an attorney, the court will appoint an attorney and furnish the attorney with portions of the transcript and record necessary to handle your appeal. This request must be made within 42 days. You're now being handed a form through your attorney inquiring into your financial condition and requesting such appointment, and I request that you sign the receipt for the form.
This one has a receipt right here.
Put the date in. 7/21.
That's where it happened at. I don't see it. That's where I stay.
All right, then if there's nothing further, this matter is completed. Everybody have a nice day.
Thank you, Judge.
Thank you, Your Honor. Thank you, Your Honor.
Hi, Judy. What is going on? How are you doing?